Hello and welcome to episode 2 in the GLG Legal Property Law series on contracts, more specifically unconditional contracts. I propose to deal with commercial contracts in a later section. What I propose to deal with today is what types of conditions you might look out for and wish to add into the contract. Now, when we're looking at a contract for a buyer, we need to make sure that the buying entity is 100% correct, including the name, its ACN if it's a company, and any details of the trust if it's meant to be buying as a trust. The law of stamp duty in Queensland is quite harsh, and it is very difficult to change a party to a contract. There is a risk that you'll impose double stamp duty by doing so, and it simply can't be done without the cooperation of the seller. You cannot unilaterally change the name of a buyer, so it's quite a big process. In reality, we would normally have to do a deed of rescission and a new contract, which obviously sellers don't like, and even if they agree to it, they'll insist on payment of their legal fees. So it's a process to be avoided. The buyer should always conduct a title search prior to signing the contract. They can check on the registered records. It'll also alert us to any registered encumbrances, bearing in mind what I mentioned earlier about the way the contract should be prepared, noting any encumbrances on the contract. It might alert us to any easements which may have a bearing on the buyer's decision to purchase the property, or perhaps there should be easements in the case of reciprocal driveways or things that we know about. I've mentioned that the property section should be fully completed with all the details, and the area, as I've mentioned, the area of land causes quite a lot of problems. You must ensure that the area expressed in the contract is accurate as per the real property plan or a survey report. Otherwise, the vendor could end up paying substantial compensation even if there's a minor error in the amount. The present use I mentioned previously causes some problems. It's not simply a case of looking at what's there and writing it down. The present use refers to what is permitted by the town plan, or more correctly, the contract assures the buyer that the present use is permitted by the town plan. So if in fact there's a use on site that's not permitted, as a warehouse in a residential zone or something like that, then a number of problems arise with respect to this. It goes beyond the scope of this seminar to deal with that here, but please be careful of that, and please make sure you talk to your agent and your solicitor if you have any concerns about the use of the land and the present use. As with both of the REIQ contracts, the important material is contained within a small number of sections. Page 1 of the items section has provision for the buyer's solicitor, the buyer, the seller, their solicitors and so forth. The really important section is the property section, which is the bottom half of page 2, the purchase price and some other information on page 3, and in my view the going concern provisions, which are in page 4. Note, the going concern and other GST provisions are not included in the residential contract. The residential contract states that the purchase price includes GST, full stop. There is no provision for recovering additional GST. There's no provision for provision of a tax invoice or payment of GST. If you're using a residential contract, be very careful if there's any GST implications. If, for example, the seller is a property developer, or they're looking to use the property for some commercial purchase, or they're buying a farm, these are all things which might mitigate against using the residential contract. I'll deal with the GST provisions in more detail later. On both the contracts, the lawyers and agents are foisted with a large number of provisions with respect to smoke alarms, fire safety certificates. They're not pool compliance and so forth. Of course they're not irrelevant and they are of some significance, but I don't think they go to the root of the legal title, nor should they be part of the conveyancing process, nor interfere with the rights of the parties to a property contract. Yes, they're important, but perhaps we should deal with them elsewhere and not in the terms of these contracts. The types of special conditions we often see will vary on the nature of the contract. Residential contracts, there's rarely any special conditions. It's often the case that they are subject to finance and subject to building and pest. And that's normally sufficient for the buyer to conduct their inquiries and ascertain whether they're happy to proceed or not proceed, as the case might be. Commercial contracts are less likely to be subject to finance and very unlikely to be subject to building and pest. Most commercial buyers, however, would prefer to have the contract subject to a due diligence inquiry, which is generally a search inquiry of the buyer, which would normally take more than 14 days. So generally we look for 21 days for a due diligence period for a buyer, or 28 days if we need to do a standard town planning search, because that's how long council take to come back to us. When the buyer gets these reports, they'll read them, and if they're happy with them, in theory they should proceed. The problem with this for a seller, of course, is there's no guarantee that the buyer is going to proceed until they get confirmation of due diligence. Unfortunately, they have to spend quite a bit of money with agents, advertising, taking the property off the market, getting their lawyer to prepare the contract and advise, negotiate with the buyer's lawyers, and backwards and forwards. It's completely understandable that $5,000 to $10,000 or $15,000 will be spent by a seller in that process, and yet the buyer simply changes their mind and walks away during the due diligence period. For this reason, I'm increasingly recommending to my seller clients that they get a non-refundable component of the deposit of, say, $10,000 or $15,000, so that even if the buyer does pull out, that money remains with the seller to indemnify them for these sorts of costs. Bear in mind, it's really only the buyer who's going to know whether they're likely to get finance, whether the property is likely to suit their needs, because we don't know as seller what their needs are, what their financial position is, or anything else. And we don't really want to embark on that investigation. We just want to deal with a buyer who we have reasonable belief is going to proceed with the contract. And putting in some hurt money is a good way to ensure that they're not wasting our time. Where it's a strata title property, both in commercial and residential, it's not uncommon to have a provision for 14 days for inspection of body corporate records. The Body Corporate and Community Management Act gives the buyer statutory entitlement to terminate the contract if there's a material departure between the information provided to the buyer in the disclosure statement and the records that the buyer sees when they do the body corporate inspection. Accordingly, then, it's very important to get your body corporate inspection records done within the first week. There's no point in getting it on the 15th day because you can't do anything about it if it's defective. So get it done early and report to the buyer, who can then make their decision if everything's in order. This doesn't give the buyer carte blanche to walk away just because they don't like the report. If the report reflects what's written in the contract and or the disclosure, the buyer is stuck with it. Their right is to terminate if there's a material departure from what's written in the contract, from what they find in the records. With respect to due diligence clauses in commercial contracts, apart from insisting on some non-refundable deposit if I can get it, I also like to include a provision that the buyer waives the right to object to any defect which is obvious to the buyer or should have been obvious as a result of their due diligence inquiries. By that I mean it's quite possible that a buyer might find a material defect in the property which gives them the right to terminate under clause 7 of the contract, standard condition 7. So they're fully aware of that, makes the property substantially defective, and yet they elect to proceed under the due diligence clause, which is their right. And then they write to us and say, I'm going to terminate the contract under clause 7 and claim damages from you for $100,000. There's nothing to stop them doing that. They were aware of it when they confirmed due diligence, and yet the seller ends up being exposed to liability. That's something that should be avoided, and hence a recommendation that the buyer must live with the material they discover during the due diligence period. In acting for a seller on a residential contract, the things that we will want to look at particularly are ensure that the seller's name and the residential details and real property description are accurate as per the title. We should conduct a title search for that purpose, and that will also alert us to any encumbrances or easements that are on the title. It will tell us who are the mortgagees, because we need to contact them to get a release of the mortgage. Unfortunately, I've seen many contracts where simple easements are not noted on the title. Again, this gives the buyer the right to terminate the contract, as it will always be a defect in title, but more commonly they might proceed and claim compensation. So even though the buyer might have known about it, the fact that the agent forgot to write it in the contract might give the buyer the opportunity to get a windfall gain of, say, $5,000 or $10,000, as well as incurring substantial legal costs on both sides in doing so. It's easily avoided by getting a title search from the outset. Again, make sure the area is accurately described and the permitted use, so far as we know under the town plan, is accurately described. If the buyer is a company, it's imperative that we do a company search and ensure that the person we're dealing with is the person authorised to bind that company. It's also imperative to get a director's guarantee. Now, when you're dealing with a company, there are two ways to ensure security. One is to take the full deposit permitted, which is 10%. So if you're selling for $1 million, a $100,000 deposit goes a long way to protecting you from all sorts of damage and defects. However, most buyers won't pay a $100,000 deposit. They may pay 50, they may pay 25. That would hardly cover the agent's commission, which I'll touch on briefly in a minute. But if they only pay that small amount, the real risk for you is that you end up in litigation with this $2 company. Now, you know it's a $2 company, I know it's a $2 company, and they know it's a $2 company, and yet they can take you to the Supreme Court. Or more correctly, if you take them to the Supreme Court arguing over the contract, you may incur hundreds of thousands of dollars of legal fees. Even though you know you're going to win, and you do win, you can't execute your judgment. You cannot recover those costs. And this will be used against you in the process of that litigation. They know that you know it, we know it, and you will end up having to compromise your claim simply because you know that they can't pay it even if you get a judgment. The way to avoid that is to have the director's guarantee so that he's on the line as well as you. He's got as much to lose as you have by going to unworthy litigation, and they're much less likely to do it. Now, for the seller, we don't want that interest rate change that I mentioned is 10.6%. But if you're acting for a buyer, it's probably a good idea to alter the contract to reduce that to what you might consider a reasonable rate, say 6 or 7%. Most sellers would think that's fair, even though they might not like it, and it will certainly be a material benefit to your client if they do happen to default in payment or need to extend the settlement date. If you're acting for a seller, we'd like to see the buyer waive the cooling off period. Now, under the residential contracts, the Property Operations Act provides for a 5-day cooling off period unless it is waived by the buyer. There's no limitation on that waiver, you simply have to get them to complete a form. It's rarely done and is very uncommon where there's subject to finance or subject to building and pest because they run in parallel. But if you do have a cash contract, make sure you get that waiver of cooling off period. Just pay attention to those pesky regulatory provisions that I mentioned before, the pool safety certificate, smoke compliance, smoke alarms and so forth. I had an example recently where the contract was worth $5 million and they didn't give a smoke compliance certificate. And while they were going to demolish the property, and yet because we didn't give the certificate, they were entitled to 0.15% of the purchase price, which worked out to be a lot of money on a $5 million property that's going to be demolished. We were able to get around it in the end, but it can add up, so be careful of that. Just talk to your accountant about the GST obligations and the withholding tax. In fact, it's a good idea to talk to your accountant about any tax implications of a sale and also a purchase. Any sale other than your residence will probably be subject to capital gains tax. If you're making a profit of $100,000 or $200,000, the taxes will be substantial, and it's very worthwhile speaking to your accountant beforehand because there may be ways to minimise that tax. Maybe simply deferring the contract date to fall outside the 12-month period, for example, may halve the tax liability that could arise. So it's very worthwhile paying attention to that. There are GST withholding obligations now, which you need to consider, and again, speak to your accountant about that. Now, for a seller, I want to talk about land tax for a minute. When I first started law, you had to be a land baron to even think about land tax. If you didn't own 25 properties, you didn't have to think about land tax. Because the land tax threshold is, and always has been, in the order of $500,000 to $600,000. And 40 years ago, properties were $20,000 each, so it took an awful lot of properties to get to that figure. Unfortunately, the thresholds have hardly moved, but the land values have now gone from $20,000 to $700,000, so you only need one property in order to pay land tax. If you have several of them, you'll probably get a very substantial land tax bill. There is simply no provision in the residential contract for recovery of land tax, so if you want to recover land tax, make sure that you insert a land tax recovery provision. There is a land tax recovery provision in the commercial contract, but it is ineffective, or certainly not as effective as it should be. I say that because it says that the seller is entitled to recover the land tax which an individual seller would have paid if this was their only land. Remembering that an individual seller gets a $700,000 tax-free threshold. However, if they've got several pieces of land, they're going to be well over that threshold, and if this particular piece of land is worth $600, then they'll get no recovery from this land tax. If, however, the contract is changed to say the seller will recover the proportion which relates to this land of the land tax that he's actually paid, then he may well recover several $1,000s. Another problem is that if the seller is a company, their threshold is closer to $240,000. So it's quite conceivable that the company will be paying sizable land tax and they don't get the individual concessions. And yet the contract still provides for their adjustment on the basis of one individual person. So that's simply unacceptable. Again, I changed that wording to state that the land tax will be adjusted on the amount actually paid by the seller with respect to the subject property, and that is easy to calculate. In fact, the land tax statement that the client receives will identify the property, its proportion of the value and the amount of land tax payable. That can save the client tens of thousands of dollars just on the land tax adjustment alone, and it's very worthwhile. Ironically, land tax is assessed on the 1st of July every year, so this is a very important issue in August, September, October, when we've still got 9 months left to run in the year and there's a very sizable adjustment. However, it gets less and less important May and June when there's only a month or two left in the financial year. Again, with commercial contracts, I've mentioned previously that there are seller's warranties under clauses 7 that allow the buyer to terminate by notice any time up to the date of settlement. I frequently see a seller who smugly thinks that their contract is unconditional and it was signed 2 months ago and there's 2 months to go to settlement, and they are assured of getting their sale proceeds in 2 months' time. Unfortunately, those clauses are still current and the buyer can still terminate before the settlement date. With a view to making this contract more unconditional, it is my practice to change that date in those in standard condition 7 so that the buyer must give notice within 30 days of the date of the contract. I think it's fair to give the buyer a reasonable time to conduct their searches, and if they find a problem, for them to notify us so that everybody knows there's a problem. It gives us a chance to respond, possibly rectify it, and decide what the seller's going to do about it. However, I don't think it's fair for the buyer to simply not do the searches until the month prior to settlement, or actually do the searches and know there's a problem and then sit on the contract knowing they can terminate at any time. That's a most unfair outcome. And the best way to avoid that is to change the reference to settlement date where it appears in clauses 7.7, 7.5 and 7.4 to the date which is 30 days from the date of the contract. So the buyer has the chance to complain or object. If that 30 days pass and they haven't done so, then they've waived that right. Once again, while there may be common law rights with respect to these things, the courts are less likely to intervene if the buyer had a reasonable time to conduct their inquiries, had a reasonable time to object, and elected not to do so. I don't think the courts would intervene in those circumstances. I mentioned briefly the Body Corporate and Community Managements Act. Of course, strata title is a different type of ownership. It involves community ownership, it involves body corporates and bylaws, community title schemes and so forth. Not surprisingly, the strata title contracts include specific provisions dealing with the body corporate entitlements, prohibitions on the vendors making any material alterations to the body corporate or body corporate voting, and adjustments for body corporate are made in the contract and so forth. I won't go into detail here. Suffice it to say that residential strata contract is very similar to the contract for house and land, and the commercial strata contract is very similar to the commercial contract which I've referred to. The big difference at the moment is that under strata title contracts there is a requirement for a disclosure statement which sets out the body corporate levies, the name and address of the body corporate, and various other important issues. Recent amendments to the Property Law Act in Queensland will be bringing that disclosure regime to all contracts, so the difference between the contracts is soon to dissipate, and no doubt that will bring about another edition of the REIQ contract, bearing in mind that we're currently on the 18th edition, so 19 must be on the horizon. That concludes my comments on episode 2 of Unconditional Contracts.